So, hi everyone. I hope everybody's doing well. I'm Nikki Kenyon, an Associate Managing Director at the Institute for Financial Integrity, or IFI. We're going to discuss the Corporate Transparency Act, and apparently it's a huge thing of interest to all of you. So let's talk about this. Congress in 2021 passed the Corporate Transparency Act, or CTA, creating a new beneficial ownership information reporting requirement, right? So the effort aims to make hiding or benefiting from illicit gains through the use of shell companies and other opaque ownership structures a bit more difficult for illicit actors. So as you know, shell companies in the United States have been used to move and hide billions of dollars in illicit proceeds. The beneficial ownership information database that'll be administered by FinCEN is part of the effort to detect and deter these illicit activities. So a small example, I'd like to flag yesterday's designation by OFAC. Pullman Global Solutions was sanctioned for being owned 50% or more by Latvian national. His name is Andrejs Bradens. I'm sure I've probably mispronounced the name, but he was also sanctioned yesterday pursuant to Executive Order 14024 for being part of this TGR group, an extensive money laundering and sanctions evasion network that was, that helps Russian oligarchs evade sanctions. Pullman is located in Wyoming. Its founder is an attorney. His name is Scott Sedahl, and his Sedahl Law Office, also located in the United States. Our research has Pullman's registered agent as Alpine Company Services, LLC, also founded by Mr. Sedahl. But it's owned, the actual company is owned by Bradens, the Latvian nationals, according to OFAC. So wouldn't it have been great if a firm or financial institution doing its research was able to determine the company's beneficial owner and avoid doing business with a possible illicit actor? Even if Bradens wasn't sanctioned at the time, right? The organization doing its research could have determined whether or not they wanted to transact with this individual based on the information available, and maybe even include him on an internal block list. So we'll talk a bit about that and the importance of transparency in this effort. In addition, there's been a development this week regarding the CTA, so I'm going to address the elephant in the room right now. The judge in Texas granted a motion for a nationwide injunction sought by the National Federation for Independent Businesses, or NFIB, as part of its lawsuit challenging the constitutionality of the CTA. The judge ruled that the CTA is unlikely unconstitutional because it's outside of Congress's power, meaning that companies required to report their beneficial ownership information under the CTA supposedly need not comply with the law by the January 1st, 2025 deadline. So with that example and all of this, let me introduce our panelists for today. And they are, I am not kidding you, stellar, okay? So first we have the absolutely glorious Jim Richards. Jim is currently the principal and founder of RegTech Consulting, focused on providing strategic advice on all aspects of financial crimes risk management. Jim and I have done panels together in the past and had a great time doing it. And given his vast experience at Wells Fargo and all sorts of financial crimes, he'll be a wealth of knowledge on this panel. Next up, we have Gary Kalman, the Executive Director of Transparency International US, where he oversees the organization's US operations, focusing on illicit finance and the US role in global anti-corruption efforts. Gary is amazing. He was a founding member of the Financial Accountability and Corporate Transparency Coalition, or FACT Coalition, back in 2012. And that is a nonpartisan alliance promoting policies to combat the harmful impacts of corrupt financial practices. And he was also the executive director from 2016 to 2019. You want to understand corruption from a policy perspective? Gary is big time, and I will be throwing him under a bus a lot just to talk to you. He doesn't mind, trust me. And last but definitely not least, we have Debbie LaPrevotte. Deb is a former FBI agent with whom I worked pretty closely on sanctions-related issues after Russia's invasion of Crimea in 2014, when I was still at Treasury. Deb is amazing. She's an incredibly smart investigator. She spent 28 years investigating some of the most corrupt world leaders, following the money and recovering stolen assets. While at the FBI, Deb seized more than $1 billion from foreign corrupt leaders, none of which she has given to me. So I'm a little angry with you about that. We'll have a chat afterward. But, she's also worked as a senior investigator for The Century, which was founded by George Clooney. She's also currently helping the U.S. State Department with their criminal investigations. And she's the executive producer of her own podcast. It's called A Nation of Thieves. So as you can see, stellar. Did I say stellar? Okay. So we did have an official from FinCEN initially, but he had to cancel at the last minute. So I want to give you guys, first and foremost, the statement from FinCEN as far as the CTA decision goes. So they sent the following. The Corporate Transparency Act plays a vital role in protecting the U.S. financial system, as well as people across the country from illicit finance threats like terrorist financing, drug trafficking, and money laundering. We continue to believe, consistent with the conclusions of other federal courts, that the CTA is constitutional. Yesterday's ruling, they sent this yesterday, so the day before, is one of several cases pending before courts around the country, including ones in which district courts have denied requests to enjoin the CTA and that are now before courts of appeals. We're reviewing the ruling to determine our next steps. We would refer you to the DOJ for any further information about the case. So we're not going to discuss the case writ large. We're not lawyers, but it is something that I've heard from other attorneys and former government officials. So we'll discuss further in a bit. What we'll do is start off by giving you a quick overview about the beneficial ownership effort, who's required to register, who will have access, the security of the information, what's involved, etc. This information is on the FinCEN website, and I would encourage you to go over there and check it out. There's a link to FAQs in your chat, in your documents, so you'll be able to access that. Then we'll discuss why this effort is so important, what it means for transparency, how this information could be useful for those doing due diligence research and investigations. And I think Deb is going to be really, really important in discussing those types of issues. We'll talk about where this effort could go from here. What are the next steps? What would be useful? And no, we're not going to forget questions from the audience. Please put your questions in the chat so I can pull them seamlessly. We also have a ton of questions folks sent in advance. Like I said, this is a crazy popular issue. So I want to highlight one thing. We are not your attorneys. Nothing we say today should be considered as legal advice, okay? We don't know the specifics of any given situation, so we're kind of responding more broadly. But again, go to that link to the beneficial ownership information FAQs, and you should, at the very least, be able to, get some of your questions answered. So first, some general information about the beneficial owner database. Who's required to register? I'm going to go through this quickly as an overview, since FinCEN's robust FAQ page addresses a lot of this information. I'll paste the link into the chat so you guys can access it. Any corporation, limited liability company, or LLC, or other entity created by filing a document with a Secretary of State or similar office in the United States, unless they qualify for a specific exemption. Essentially, most businesses form through official state filings. need to file a BOI or beneficial ownership information report with FinCEN. Who's going to be able to have access? Federal agencies, those involved in national security, intelligence, or law enforcement, state, local, and tribal law enforcement agencies with court or authorization, foreign law enforcement agencies with a request through a U.S. federal agency, financial institutions, and they will have to get customer due diligence requirements, and they'll have to get authorization from the potential customer or current customer about, accessing that information. And then federal functional regulators that supervise financial institutions' compliance with customer due diligence requirements. Will the information be secure? I've been told yes. There's a training requirement to ensure those who access the beneficial ownership information understand their responsibilities. Those accessing this information will have to have a memorandum of understanding with FinCEN that outlines how they'll protect the security and confidentiality of the BOI. And they must guarantee that they'll be able to abide by the access and safeguards rule and not disclose this information. It's similar to what we had to do to access BSA data or suspicious activity reports when I was at Treasury. There are civil and criminal penalties for unauthorized disclosures. So be aware of that. Anyone else have anything to add to what I just said before I move on?
So, Nikki, I would point out that those exemptions are pretty important. And two of the exempt species of entities are money service businesses, which includes crypto exchanges. They're exempt from submitting their ownership information, as are companies that have 20 or more employees and 5 million or more in revenue and a physical location in the US. And I'd point out that latter group, they're perfect front companies, but they were exempted by Congress from having to submit beneficial ownership reports. And then the other thing is, and you talked about Pullman Global Solutions. Another limitation of the act is that if your customer or prospective customer is Pullman Global Solutions, you could reach out to FinCEN with Pullman's approval to obtain Pullman's beneficial ownership information. And let's assume that you found out it was who is this guy, whatever he is, an Albanian or whoever?
He's from Latvia, but yes.
Latvia. Okay, so now you've got this Latvian guy. What you cannot do under the CTA is go back to FinCEN and ask the obvious question. What other entities is he a beneficial owner of? You cannot do that. So two limitations. They have to be your customer or prospective customer with consent, and then you can't query for beneficial owners. You can only query for reporting companies.
Yeah, and I will add this. So there are tools that you can use to, take a look at this guy and what he's involved in, what he's linked to. There are due diligence tools. And actually, Deb and I had a conversation about this last week. And yeah, it would be really nice to know what else is he a beneficial owner of? What kind of, how does this impact investigations? So yeah, absolutely. All right, so given yesterday's decision in Texas, I'm going to, the first time, throw Gary under the bus on this. Gary, what are your thoughts?
Sure, and thanks for inviting me, and glad to be here with my colleagues who we've worked with for a long time, so good to be here. So the decision is, I will say, it's a well-written decision. We think it's obviously wrong from our perspective. It's not, but it is, it is a decently written decision. I will say, though, that the judge may have sort of revealed his hand in his bias when he called it an quasi-Orwellian piece of legislation. Let's be clear what the one thing I do want to add for folks is what the legislation requires is 4 basic pieces of information about yourself And then if you hire somebody to file it, they also have to provide some basic information. It's your name, your address, an identifying document like your driver's license, your name, address, driver's license, and date of birth. And that's it. We provide more information if you want to go get a library card in all 50 states in the country. We provide, in fact, I think we haven't yet found, although if somebody finds something, let me know, any federal reporting requirement that requires less information. There's no economic or financial information. There's no business purpose. There's no, there's no other information. It's basically a pretty straightforward law. So on its course, on its face, we don't think it's very burdensome. I would also say that there are 11, I should also note that there's 11 cases currently going through courts. So this is just one case. As you noted, there's some that went the other way and said, no, we don't think that this is unconstitutional. The case that's currently furthest along is before the 11th Circuit. And one of the questions from the judges, which might be an indication where the case might go, although you never know, was one of the arguments that was put forth by the plaintiffs in their brief. One of the judges said that we didn't understand the legal basis. It was more of a political argument about burden, and asked the plaintiffs lawyers to describe their concern. And after it was, the lawyers responded, the judge said, I still don't understand it. So that's just to put it in context. But let me go two things, what the arguments are, which I think is what's really important here. So one is that corporations are started in the states. They're incorporated at the state level. Congress doesn't have the right unless there is interstate commerce. So that's the first argument. And then the second argument, which is actually a fairly important argument, is that this law has absolutely nothing to do with foreign affairs, foreign policy, or national security, which is in the purview of Congress under the Constitution. On the former, so looking at does Congress have a right to regulate businesses, the argument is the filing of a document to start a company is not in fact interstate commerce yet. And so it is premature to ask them to do that. When judges ask the plaintiffs, so do you have any client that doesn't engage in interstate commerce? Because understand that having a website that is hosted across state lines is in fact interstate commerce. They literally could not come up with a single plaintiff that met the definition of not having interstate commerce. So it is a fairly, I'll say, unique argument that would have implications for the Commerce Clause more broadly. The second argument on national security, and I assume one of your questions later on is going to be, give us some examples of problems, and we can go more in depth. But between sanctions evasion, illegal arms trafficking, fentanyl trafficking from China, the argument that this does not, in fact, there's anonymous companies that were involved in some very, very concerning businesses when we were dealing with companies in Afghanistan. The argument that anonymous companies in the United States are not threatening or posing a risk to national security or foreign affairs is simply not true. So, and there's a number of national security folks that have spoken out on that. So we think at the end of the day, because of differing decisions and the multiple cases, this will end up at the Supreme Court. We also feel, and I'm going to say cautiously optimistic, I don't want to get overly confident, but we do believe that at the end of the day, it will be upheld. Last thing I'll say, and then I'll stop, is currently, if you're asking right now today, do I have to file? And the answer is there is a nationwide injunction that is in place and enforcing the law. And so technically you don't have to file. You check with your lawyers on whether or not they think it's going to be overturned. You might as well file, or you want to wait. That's your risk tolerance and not my decision to make for you. But currently, there is no ability to enforce the law as of heading towards January 1.
And I will say this. So I went into the FinCEN website and I took a look at what's required to file, and I was like, this is nothing. There's more about me on social media than there is in this particular thing. So we'll see where this lands, but yeah. Jim, do you have something to add?
No, I think Gary summed it up really well. I mean, there's a split, and it's probably going to end up at the Supreme Court, and we'll see where it lands. But we probably won't know anything before January 1st.
Yeah.
Yeah.
Yeah. Deb, anything from your end?
No, Gary, again, great overall summation of it's just so the information. I mean, as a law enforcement officer, or former law enforcement officer, it's like the you know, if I introduce myself to somebody, I get more information than they're asking for to file. And you know, I have an LLC, I'm filing, and of course, you know, I'm the only beneficial owner, so it's very, you know, it takes 10 minutes of my time, if that. But I think, you know, the people who are opposed, I'm like, you know, what do you have to hide? Like, you know, why do you not want to identify your beneficial owners?
Yeah, and Deb, I'll say you're very sketchy, man.
You know, and it's true that it probably takes about 10 minutes. It took me 10 minutes. I registered my company on January 1st. But very recently, I was helping someone. They said, hey, I was at my business association. Everyone's talking about this beneficial ownership thing. Can you help me do it? And I go, sure. And they said, okay, so where do I go? And I go, I'm not telling you. You figure it out. And it took 10 minutes to figure out you had to go to FinCEN. And then it was very well done by FinCEN. But the second question they ask you is, do you want a FinCEN identifier? And then it was like, what's a FinCEN identifier? Why would I need one? What is it? And that it was just very, very kludgy at that point. So FinCEN's tremendous effort. There's still a few little tweaks. Apparently only about 8 million of the estimated 35 million companies have submitted their BOI reports so far. So maybe this timeout caused by Texas may not be a bad thing, I think, if we can smooth out some of the wrinkles.
And I'm quickly going to ask this question because it's actually relevant to what we're talking about. The obligation to file still remains, correct? It's just the enforceability of it that's enjoined. Anybody want to respond to that?
Well, they put in a nationwide injunction on enforcing the law. So not file, do you have to file? Do you not have to file? You can't, there's no penalty for not filing. So it's sort of I'm not quite sure how to answer that question. Right now, I would say it's the equivalent of you do not have to file.
But that's not legal advice.
But it's not legal advice. No, I am not offering legal advice. I would also say, you know, there has been moves in Congress, and, you know, FinCEN has thought about, you know, pushing back the deadline a little bit. I think a couple of things that we want to wait and see, and this court case will certainly add into people's mix on whether they file or not. But Jim's completely right that only about 8 million, and just so people know the context of it, there's about 33 million businesses in America. Probably 32 million have to file. There's 23 exemptions, but they're fairly small amounts of companies, right? That said, you know, in the first 6 months of the year, I think about 1 million companies or 2 million companies filed. FinCEN is now getting upwards of 800,000 companies filing a week. At that rate, you're still not going to get up to 33 million, but it's been growing exponentially. And as we get closer and people realize that they need to do it, I think two things are happening. One is lawyers and accountants and other corporate service providers are telling their clients, hey, by the way, if you haven't done this, you should do it. And the second is that FinCEN, you know, God bless them for their outreach to small business and try to, you know, get people aware of it. But the thing that's really making the difference is 45 states have now put buttons on their corporate registration sites, and the IRS has put a button on its website. So those filing quarterly taxes are going to see this button and know they have to file. Those filing their annual reports or registering are going to see it. That's really where you're going to get millions of businesses that FinCEN will never be able to reach, to at least know that it exists. And hopefully know enough to ask the question. So
And IRS serves everybody, so yeah. Okay, so let's move on. I want to discuss the effort writ large. Why is it important? So I'm going to address this this question to both Deb and to Gary. Deb from an investigative standpoint, and then Gary from a policy perspective. Why is this beneficial ownership effort important? What is going on? Why are we all of a sudden all up in arms about beneficial ownership?
I'll start. Yeah, because we're not all of a sudden, right? I mean, we've been addressing this for over a decade. And Nikki, going back to 2014, when Russia invaded Ukraine and we're over in Kyiv, and all of a sudden we looked at all of the money, how $40 billion left Ukraine, right, under Yanukovych. And what we started to see is how many U.S. shell corporations were used as modes of facilitation to help move money out of Ukraine. And I'll give a real quick example because it's so pertinent to this conversation. There was a $60 million vaccine contract that Ukraine signed under Yanukovych with an Oregon company called Olden Group. And on that contract, $30 million worth of vaccines was provided, but that means someone walked away with $30 million of profit on one contract out of Ukraine. So this is one of the methods, procurement fraud, that was used to move money out of Ukraine. So I got that investigation and I looked into Olden Group and I called the registered agent for Olden Group and I said, who called you? Who called you and said I need a US company? And it was a company out of Belarus. And I said, okay, well, could you tell me how many companies have you registered for that service provider out of Belarus? He goes, oh, 1,956. So there is 1,956 companies as of 2014 that were incorporated for individuals, probably Russian, Ukrainian, Belarus oligarchs. And you have to ask, of those 1,956, how many have no U.S. footprint? If they have no U.S. footprint, what were they utilized for? Because we know at least one of them was used to commit a $30 million fraud. And it goes to, you know, the Ukraine tried to sue Olden Group, but there is no Olden Group. It just has a registered agent in the United States. There was nobody to sue. There was no bank account. There was no company that you could take legal action against. So when people ask me, like, why is beneficial ownership transparency so important? That's why. Because Gary and I were working years ago when he was at the FACT Coalition and trying to promote transparency. And I just started looking into how many times U.S. corporations were used in foreign fraud, in an Italian Ponzi scheme, in another case out of Lithuania. I had so many examples of U.S. corporations used to commit fraud abroad. And because when they see it's a U.S. company, that adds an air of legitimacy. And clearly, we need to clean up our own backyard.
Yep. Gary?
Yeah, so thanks for this question. I think it is important for people to understand. So let me say this. This is not transparency because a bunch of good government people think that it would be healthy to have transparency, right? This is years and years of folks like Deb and Jim and others, you know, trying to protect the U.S. financial system against fraud and protecting the U.S. citizenry. So let me give you a couple of examples and then refer to a study. But, you know, Victor Boot was recently in the news in the past year because he was given in a prisoner exchange. Well, who's Victor Boot? Nobody remembers him. Well, he was one of the most notorious arms dealers in the history of the world. How did he move arms and money and everything around the world? By setting up shell companies a bunch of places, but including in Texas, Florida, and Delaware. Without that, he couldn't have moved arms into the FARC or to Liberia or where, you know, in the numerous places, conflict zones around the world. That's actual harm and danger. Perhaps the scariest one that I've seen recently or saw in the last few years was that the U.S. government, the Defense Department, when trying to provide services to troops in Afghanistan, they contracted with a U.S. company that said that they had ties to Afghanistan. They didn't get the beneficial owner, and it turns out that that company was secretly owned by sympathizers to the Taliban. We were literally providing money to the people that were shooting at our troops. So these are the kinds of stories that you really have to go, this is not just, good government folks. This is actually a real threat to our national security. Fentanyl trafficking is another big one. Chinese companies setting up U.S. companies and moving money and drugs into the U.S. So we could go on. The thing, though, that I would say is at one point somebody said, yeah, I've heard enough about the anecdotes. There's a study that is years and years old. I get it, years, maybe 10 or 15 years, but it still is a seminal study that was done by the STAR initiative, which is an initiative between the World Bank and the UN. And they found, looking at, I think it was 30 years of grand corruption cases, and that in 70% of those grand corruption cases around the world, an anonymous company was at the core of moving that money around. So anonymous companies are the getaway vehicle that are favored by the criminal and the corrupt. And we could put all the money we want into law enforcement and, have Deb and her colleagues run around trying to follow the money as we say, but we can't do it if you run into a brick wall and you don't know who's behind the company. And so this is a critical national security and public safety tool.
Yeah, and Nikki, if I could just point out, when I was looking at the congressional record for the AML Act and the Corporate Transparency Act back before it was passed, back in 2020, I was looking for discussions by Congress about the existing beneficial ownership regime that we've had in place since 2018. There was no mention of it. So I'm with Gary and Deb. This is critical information. Very difficult to get, very difficult to verify, but it's information we need to have. But I was struck by the dearth of information on whether and how law enforcement has been using it, or national security has been using the information that's been collected for 6 years now. So I would like to see whether and how the current regime has worked, and if it has, why, and if it hasn't, why not, in order to inform this new regime. And there hasn't been anything about it.
Yeah, no, I absolutely agree. And actually, one of my subsequent questions was going to be that the database is really described as a good first step, and what would make it more useful and more beneficial. But before I do that, so here's a question from somebody. Considering Jim's concerns about the exclusions from the obligations, do you think that this information is actually is it gonna achieve sufficiently the objective for transparency that's needed to prevent financial crime? So what kind of challenges are we seeing? I'm going to toss this one to Jim first, and then I'm going to have all of you kind of chime in.
I think Gary needs to take Gary, because I know you've talked. No, Gary's done a really nice job talking about this before. So,
Bus, meet Gary. Go ahead.
Okay. Nope. Happy to kick this one off, but I'm sure others have additional concerns. Look, there's 23 exemptions. Some of them we're actually not that worried about. I will be honest about that. We had publicly traded companies already report to the SEC down to 5% ownership. No one's, bad guys might have investments in Coca-Cola, but they don't control Coca-Cola, right? So those kinds of exemptions that are already reporting or are, so large that they have enough regulatory oversight, we're not that worried about. I do think, and I'll just go back to what Jim said earlier, that the operating company exemption, this is the $5 million, 20 employees, we think that's too low. There's a point at which a company is big enough that, law enforcement says, look, if there's enough people working there, we'll find somebody who knows what's going on and they'll give up the goods. Is 20 employees the right threshold? I think with Jim, I'm right. That I agree that that's a concerning one. There's also private investment vehicles, and they are very easy to set up. They have a very limited reporting to the SEC. Let me say it this way. Entities that have are already reporting enough information to regulators, either at the state or federal level, I think we are less concerned about. But there are a few of these exemptions that we are watching for exploitation because they don't have those kinds of reporting requirements or oversight by other existing federal regulators. And so we want to watch those and see if those loopholes become the loopholes that swallow the law. For now, I think, I would argue that this is an incredible, as you say, important first step, but we do have to watch it to make sure that it is actually getting the information and not creating ways in which evasion can swallow the thing. So I think I think it's good, but I think there's some watching we need to do, and others should weigh in.
Yeah, and I've compared this regime so far to a vineyard. So if the goal of a vineyard is to produce delicious wine, what we've done so far is plant grapes, or we're planting grapes right now. That's sort of the stage we're at. It's going to take a few seasons for the vines to grow and for the database to build. It's going to take a little while for law enforcement to figure out how to use it. Financial institutions, those that have customer due diligence obligations and will be given access to the database, are going to have to figure out how to do it. And then there's going to be cases and prosecutions, investigations, et cetera. We're probably years away from learning whether, in fact, this beneficial ownership vineyard produces a good vintage of criminal cases.
I like it.
I love that. And let me actually add one other thing, though, that I do think, not so much on the who's covered side, but as we're thinking about the vineyard growing or the culture, let me say it this way, the culture changing in the United States, right now, as Deb noted, you have the corporate service providers, the lawyers, the accountants, whatever, that calls come in. Somebody says, hey, I'm an agent for somebody else, and they want to move money into the United States. Could you create an anonymous company, right? Or just put your name on as the registered agent or whatever. No one has to ask the question, right? I mean, those people don't have to ask the question. They just set it up. Now they have to ask the question. And if somebody gives a really sketchy answer, and you're a legitimate lawyer, that's going to give you pause on whether or not you provide services to this client. Legally, you may be able to find a way around it, but you don't want to get caught up in a lawsuit that you didn't ask the right question or you didn't do enough to, right? Blah, blah, blah. So I do think that we are beginning to change the culture, and what law enforcement, and Deb, you should confirm this if it's true, but what folks used to say to me is, if we can narrow it so that the only people creating these structures for bad guys are the mob lawyers, they generally know who they're working for. And that is a huge benefit from getting all the sort of normal, regular, honest lawyer, the corporate service agents that don't want to get caught up in criminal activity out of this game. That narrows it down to people who are more likely to know what's going on, and we can pull that thread. Again, it's not perfect, but it really does begin to change the culture of the way in which we look at corporate formation and moving money around the country.
Well, and we're Americans, right? So our culture is, it's my business, it's my privacy, I don't want to give up my information, a lot of kind of libertarian streaks through our society. But like you said, it is critical that we stop all of these illicit transactions going through the U.S. financial system. So Deb, you and I discussed this a little bit last week. What else would you like to see the CTA or the beneficial ownership database include? As an investigator, what would be useful to you?
I mean, obviously the big deal is ultimate beneficiaries, and then, and percentile. I think it's basically access. Like, how quickly do we get this information? How many layers do I have to dig when I'm trying to find who really is the beneficial owner? it's still going, I mean, there's still going to be times where people hide beneficial owner because they're putting it in a spouse's name or something like that. They're hiding their true identity, but that's money laundering. So, I mean, if it's being used to, if that vehicle is being used to launder money and they're hiding that they're the beneficial owner, but they're putting their wife, their children's name, then they are still, now they're committing they're committing fraud, and they are money laundering, right? In the attempt to hide or disguise or conceal their ownership. I think I can't say enough to what Jim and Gary have said. It's a great first step, and we are changing the culture. As a law enforcement officer, I need quick access, and the fact that prior to 6 to 8 years ago, it could take me months to determine who really is the beneficial owner. And if people understood, like when LLCs are used to purchase property, and they're used to purchase property in the where a beneficial owner was not having to be disclosed, then now you're utilizing the U.S. Real estate market to not only launder money, to hide assets, and to commit fraud. You're impacting the real estate market, right? Because you'll come in, you'll pay cash, you'll pay over a value, so the average person can no longer buy that property. It was interesting. Years ago, we were assisting the government of Nigeria going after and investigating the former Minister of Petroleum, Daizani Alison Madueke. And some of the people she was working with had bought like 5 $25 million mansions in California in the names of LLCs. And, it's like they came down to be related to one individual, but I'm like, he can't live in 5 $25 million mansions. Like, which one of these were fronts for Madueke? And so, but, if people understood what was really required when conducting an investigation and into the beneficial owner of a property, when the beneficial owner isn't transparent in the name of the LLC, I mean, you don't know. I'm talking to the mailman. I'm talking to the pool guy. I'm talking to the who's paying the electricity on the property. Who paid the landscaper, right? How do I prove you own it? The same thing with a yacht. The amount of work that is done just to find out who really does own that LLC that bought the yacht. Now, you're talking hundreds of man hours that are saved on every investigation that deals with LLCs and shell corporations. So it's just a huge first step, and it's not a difficult thing to ask for.
Yeah, and Nikki, I would actually, and I agree with Deb, the percentage ownership would be great information to have. So the current beneficial ownership rule and the CTA don't require the disclosure of the percentage ownership. So if there's one legal owner reported, they have either anything between 25% and 100% of the company. We don't know. The only one you know for sure is if there's 4 reported legal owners, then they each have 25%. Otherwise, you have no idea. But what FinCEN has done, they've added 2 things that aren't required under the statute. And that is the image of the passport or driver's license. That's not required by the law, but they added it in their rule. I think that's adding a level of complexity, both technical complexity and practical complexity, that probably wasn't necessary out of the gate. And we don't know, Deb, from law enforcement's perspective, whether that's important information or not. But the other thing they did was they interpreted the control person, substantial control, to be as many people as there possibly could have substantial control. And Gary, you and I were on that congressional panel together, and I actually said, there's not a law enforcement agent in the world that ever bursts into a layer of bad guys and says, how many of you guys are in control, right? Who's running the place? Who's in control?
Whoever has the gun.
Yeah, so I would have left it at one control person, just out of the gate, keep it simple. And then if we have to add complexity later, we can add it. But I just thought it made it a little bit kludgy to start with.
Okay. Just to jump in with a couple of things. One, in order for all this to work and work effectively, and everybody's talking, Jim talks about it's going to take a few years for these cases to sort of bubble up, and Deb talks about being able to access the information timely. I think one of the greatest challenges right now is FinCEN has been an underfunded and understaffed agency. So FinCEN is our financial intelligence unit, is sort of the term that they use globally, right? And their the equivalent in Australia, which has an economy 1/15 the size of the United States, and is not, the Australian currency is not the world's reserve currency, has a larger financial intelligence unit than FinCEN, both in terms, forget about percentage of economy or whatever, actual dollars and actual numbers of people, right? In real dollars and real people. So that is, I think, a concern that could end up undermining some of their ability to process this data and give what I think Jim rightfully asked for is this working? And can they really put together, they're not going to do ongoing investigations and reveal sensitive information, but they can give us aggregate activity about how much has this helped and all of that. And I will say that the Justice Department is starting to, one of the reasons, Jim, you couldn't find anything is the Justice Department never said in their press releases when they did investigations and had convictions that they bragged about the fact that they actually got this information from, because the anonymous company was used. In the last couple of years, we're actually starting to see some of that. And so I think they're beginning to realize that, hey, this information is valuable and we should actually let people know that it's valuable. It's not enough, it's all anecdotal at this point. But so money is one thing. And the second thing that I'd like to see with that money is verification of the data. If we don't verify the data, we already know what that means, right? Because the UK implemented a beneficial ownership database. They didn't verify the information. They had a bunch of nonsense, ridiculous at face value, like Mr. XXXXXX living at YYYYY Street, right? Crazy stuff like that. Mickey Mouse, those kinds of things. And so I do think that verification, basic verification that this is a real person, would be helpful. The way in which you do that is expensive because you have to bounce it off and compare it to other databases. And so they need some financing for that. But I think those two things are there. The one last thing I would say is I'm going to diverge a little bit from Jim's one person. And this is just my argument that 85%, I think it is, of all businesses in America are sole, non-employer firms. There's one person in the firm. This is fairly easy, which is why it takes an average of 10 or 15 minutes or whatever it is that FinCEN says to register your company. Those that create lots of complex structures and layers of complexity, as FinCEN has noted, know that there are going to be additional regulatory requirements. And if you have thousands of companies, forget about beneficial ownership. You have to provide annual reports in most states and refile, for your registration to be renewed, file the $250 fee or whatever it is every year for all of those companies. If you can manage to do that, you can manage to figure out who are the people that sit at the top of your corporate food chain. So I don't know if we need 100 or 1,000 people. Maybe there is a limit, Jim, that I'd agree with you, but I'm not all that concerned if 10, 15 people, claim control of a company. I just want to make sure that we don't set up a scenario where one person is, ends up being essentially a nominee or something and we don't get the actual bad guy. So maybe there's a middle ground there, but I'm less worried about the people that purposefully set up complex structures because I think they both have the money to do that, and that's not the small pizza shop on the corner, and they know that they're going to have regulatory burdens. So I'll just stop.
So one other question before I get to the avalanche of questions that we have right now. So given everything that we've discussed right now, right, how helpful would it be to make this information public? So instead of, having specific people or entities having access to it, would it be helpful to make it public so that, any bank or financial firm or financial institution can go in there and say, you know what, I have a prospective client. I'd really like to know what is going on. They seem sketchy. Talk.
Well, some of it already is public. I mean, you go into, if you're not familiar with searchsystems.net, you should be, because that links you to almost, I think it's every state's online databases, including their corporate type databases. So you can go into, say, Florida, for example, and pull up registered agent information, managers of LLCs, principals of companies. They have all that information. But you said it earlier, Nikki, that sort of the libertarian American streak, I think it would make it very, very difficult to have a company's house, a UK equivalent of sort of open information on beneficial ownership. I think that's just a sort of a bridge too far at this point. I think we just need to get this done right, and then we can see if we can add civil societies like Gary's that would have access to a database like this.
You know, I totally agree that this is, and full disclosure, my organization does support public registries. We didn't fight this registry because, for exactly the reason both you and Jim said, that's not going to happen in the near future. Let's just put it that way. I totally agree. You know, the UK had it, I'm sorry, the EU had registries that were completely public because of privacy laws. That was actually struck down, and now they're negotiating access by interested parties, or I can't remember the exact phrase if people know, but so, you know, for example, businesses that want to try and look for who they're dealing with in their supply chains, that might be a legitimate interest. And so they could have access, you know, some access to the database to look up who they're dealing with. Or, you know, journalists or academics might have some, you know, interest that's a legitimate, seen as a legitimate interest. So they're trying to sort of open up and find that middle ground. I think right now, given our certain culture and the libertarian streak you all mentioned, that's not likely to happen. But I hope that at some point in the future that we can take a more we can take a serious look at this and see if there's legitimate interest that we can expand access to the database. But
Yeah. Deb, do you want to add to that?
Yeah, I do. You know, it's interesting because having retired a while ago, where I unfortunately lost all subpoena authority, retiring from law enforcement, I'm amazed at how much is publicly available. But you have to search 20 places to find a lot of this information, right? There's open corporates where it's amazing how many people are listed that actually are involved with illegal activity who are on corporations. And again, I can use different databases to dig in, and maybe you're an LLC and you're owned by an LLC, but eventually maybe publicly I can dig back to you. But this is a one-shot stop for beneficial ownership. And this is, like I said, I can't stress it enough for those of us who are involved in investigating fraud. And people have to remember, for every fraud, there's a victim. And so it's important to know who's behind those frauds and who's benefiting. So, yeah, I mean, a lot of information is out there publicly. I would love to have this publicly available. I don't know how quickly that would, in one place, going to the FinCEN website, but at least having it available to law enforcement and people to FinCEN is vitally important.
Yeah, and Gary, you mentioned fentanyl a couple of times. If you think of the opioid crisis, we've got drug manufacturers, drug distributors, and then pharmacies. And the DEA has an entire system. It's called suspicious order reporting. It's similar to a SAR type of a regime, but for orders of pharmaceuticals in the supply chain there. Wouldn't it be great if those folks had access to a beneficial ownership database? But they don't, because they're not financial institutions with a customer due diligence obligation. So that's one of your interested parties, I think, would greatly benefit from this, and we'd all as a society benefit, I think, as well.
Yeah. So I'm going to go to some of the questions we've received, and I will apologize in advance. There are so many, there's no way we can get to all of them, but I found one to be really interesting, right? It's about providing beneficial ownership information to merchant processors. The question was, am I supposed to do that even if I'm exempt from reporting this information to FinCEN? For whatever reason, whether, revenues are over 10 million, whether there are over 300 employees, like whatever the reason for the exemption. Merchant processors, some of them are saying, well, we're required by the new FinCEN regulation to collect this information. Now, again, I caution, we are not lawyers, we are not your lawyers, so this is not meant to be legal advice. But to me, it just seems like this is more of a process that's endemic to the merchant processor. It's part of their due diligence. And I don't know of any requirement for that information for merchant processors. Gary, I know you kind of feel the same way.
Yeah, I mean, I'm unaware. Again, check with your lawyer. But I think that there has been a lot of misinformation that has circulated in trying to figure out this law, and FinCEN continues and should continue to put out guidance to clarify these kinds of questions. In order for someone to be reportable, they would have to have substantial control or percent, above 25% ownership. A client who's just a major processor and gives you a lot of money is not. In fact, there used to, in one of the original versions of the bill, there was a prong in there that talked about substantial economic benefit or something like that. And that was taken out because it was seen as adding another layer of confusion that didn't really. FinCEN should define substantial control. That's confusing enough for some people, and so let's just keep it to that. So I don't see how a customer would ever be unless there's some other way that they are, connected to the company, but just if you're a regular customer, I don't see it. I do agree that what maybe they're thinking is they do have due diligence responsibilities. It could be an internal company policy that they want to know who their customers are before they engage, and so they want to collect this information for their own information. But I'm unaware of anything, Jim, Deb, I don't know if you guys know, but I'm unaware of anything that would require a customer to be reported as part of a beneficial ownership regime unless there's some other connection to the company.
I'm not aware. And in fact, there were two large banks in the United States that were hit with public consent orders prior to May of 2018. And those consent orders required them to collect beneficial ownership information. And I know that in both institutions, they had customers that pushed back and said, I have no legal obligation to provide you with this information. And so absent that regulation, in fact, just sort of a policy by a company to collect the information, you may not want to bank the entity or do business with the entity, but you can't compel the entity to provide the information to you.
Yep. Deb, do you want to add anything? We have just about a minute.
No, I don't. I think this has just been great. And I think, coming from law enforcement perspective, I've covered what I think is just the most important information.
Yeah. Okay, so we got a bunch of questions that we're unfortunately not going to have time to get to. I would encourage everybody to go to the beneficial ownership FAQ page. FinCEN's got like a huge monster list that can answer a lot of your questions there. But I will emphasize how absolutely critical it is to make sure that you confer with your attorneys, What are you allowed to do? What are you not allowed to do? What's going to happen when all of this reaches the Supreme Court inevitably, especially if, circuit courts disagree. So you need to watch that. You need to monitor what is going on. Get into the Dolphin platform, and we will keep updating different types of information that come out. I just want to thank all of you for attending. Jim, Deb, Gary, it is so great to see you guys again. Thank you so much for doing this. We're very much appreciative. And I'm very, very happy to have everybody who's pitching us questions and is interested in this topic. Have a great one.